Good morning, Your Honor. Nicole Herman, HERMANN, bar number 126353.
Good morning, Your Honor. Madeline Loeb, spelled L-O-E-B, bar number 173970.
Oops. All right. Ms. Weinmiller?
Good morning, Your Honor. Chris Weinmiller with Ms. Brophy. Weinmiller is W-I-N-E-M-I-L-L-E-R, and my bar number is 863177.
And Ms. Maxwell?
Yes, good morning, Your Honor. Lisa Maxfield, also here with Ms. Brophy. My bar number is 844337, and my last name is spelled M-A-X-F-I-E-L-D.
All right. So my clerk told me there were a few things to take up before we get started this morning. I'm not sure I understand all of them. So why don't we have defense? I'm told there's something to do with a witness who was subpoenaed but hasn't shown up, or, I'm not sure.
I'm not sure we're prepared to address that yet. We're still trying to decide whether we would want the court to hold that person in contempt for not appearing. But if we could hold off on that
Come
for a
back to
second.
it. All right.
Sorry.
So my understanding is that Dr. Reesberg will be a defense witness this morning?
That's right. Based on developments just within the last couple of days, we have decided that we do want to call him afterwards. He's been on our witness list, but we were provisionally thinking that we wouldn't need to call him, and then realized yesterday that we should. So
Okay.
he, as the court may recall, has a wife who is quite ill, and so we'd made arrangements earlier for him to testify by WebEx.
Okay. And I'm uncertain if the state had matters to bring up too or not.
Well, our objection to Dr. Reesberg testifying, defense counsel had Dr. Reesberg on their witness list early on in the trial. They indicated to us that they didn't feel that they were going to need to call him. And then yesterday, they indicated they had one witness left at the end of the day, and that it was this mystery witness that they refused to identify, even when I specifically asked, who is this person, so we can do our due diligence in preparation for his testimony in the morning. They refused to identify him. I specifically asked, is it an expert? They said no. And so we relied on that information. When we prepared our rebuttal case, we have arranged an entire day of witnesses, some which have to testify today. They cannot, two of them cannot testify tomorrow. We've scheduled them out for the day to include experts. So we have our whole day planned around their representations. And then this morning at about 7:30 or so, we get an email with the fact that Dr. Reesberg is now testifying and some supporting documentation that we have not been able to fully even read yet, let alone be prepared or send it to our own expert. So if Your Honor is inclined to allow Dr. Reesberg's testimony, we're going to need some time to digest the materials that have been provided to us, and know that that's going to create a significant problem with scheduling because of our witnesses that we've arranged based on the information from defense counsel. In addition to that, I'm not arguing about the new cases that were provided this morning yet, but just
I don't know what we're talking about right now. I no longer know what we're talking about.
Defense just sent two new cases. They want to reopen, apparently, their argument against or what's going to be allowed for impeachment of the witness that we intended to call now, the person who's in custody. So they sent two cases that they want the court to consider in reopening that. We have not had an ability to read. We just got them in the last few minutes. We need time to read those, and that's going to cause even further delay. So, Your Honor, I mean, we're trying to move this case along. We're doing everything that we can to be efficient with the time and stay within the time that the court has notified the jury, and then this kind of changes everything. So the bottom line is, if Your Honor is inclined to allow Dr. Reesberg, I think we're now asking for some time to review materials.
Well, first of all, what is Dr. Reesberg being called for? So I have some understanding.
Your Honor, he is, to put it in a more casual way, he's an academic psychologist. He does not evaluate clients. He does not have a clinical practice. He is an emeritus professor at Reed. He's testified as an expert on memory in courts across the state, including this courthouse, many times. He's very, very well regarded. there were two things. First of all, we received notice, I think on Sunday, that one of the state's rebuttal witnesses is the Dr. Suzanne Best. And then all we got was a CV. We don't have anything further about what she would be testifying to. But as we were trying to figure that out, we realized that we probably, because our understanding of SIR rebuttal is that it would be limited to Ms. Jacobs and not to this issue of memory, that if we don't call Dr. Reisberg now in anticipation of what Dr. Best will be testifying to, we would then be foreclosed from developing that further, and we believe that Dr. Best's testimony may well go beyond anything that Dr. Warford was able to address. So that was the first issue that we were weighing, and as the court knows, we've got a lot of balls in the air and a lot of things to do, so we were working through that as quickly as we could, not knowing anything more about Dr. Best other than having received her CV, which I think came in Sunday evening. And then yesterday, as our client was testifying, there was a period of that testimony on cross in which issues that we had, we knew that Dr. Reisberg had an expertise in, but we did not anticipate would become relevant by her testimony. There was a period that we recognized this is exactly what Dr. Reisberg can speak to. We now have a situation where it is, in our view, imperative that we call him and provide the jury with his particular expertise. So that was all very late developing information. I will also say that, not to complicate an already complicated situation, we this morning received exhibits from the state for Mr. Azor's testimony. We got those just before 7 and haven't had an opportunity to review those. So I think going in both directions, there's material being exchanged at a very late hour, probably by necessity, at least certainly with Dr. Reisberg. We didn't have it any earlier.
And what are the documents? How voluminous are they?
Well, the two exhibits from Mr. Azor are charts, sort of like the ones that Tiffany
No, I'm
Couch.
talking about the ones from Dr. Reisberg.
There's an article that is set to be published that he forwarded. He's an author of it, and it is right on the cusp of being published. And so we provided a proof of that, and it is directly relevant to his testimony. And there's a second article that he provided that he did not author, but that addresses this exact sort of circumstance. And so both of those, I think, would be helpful both to the court and to counsel. I suppose he could testify without them, but they're definitely pertinent.
And how many pages are they?
I haven't even had a chance to look at them myself, Your Honor. We got them this morning at almost
7:15.
Yeah.
Does the state have any idea how many pages long they are?
Yeah, one is 8 pages, one is 12 pages, and the other is 14? 14
So
pages.
there's 3
one's a-
articles?
One's
There's
a
3
CV.
articles. One is an unpublished
There's 3
draft
articles.
article,
3.
and then 2 articles, separate articles. So it's 3 documents,
All right.
email that accompanies them.
And the 2 witnesses by the state that you said have to testify today, how lengthy is their testimony?
One is very short. I think even with cross, we're probably talking less than 10 minutes. Well, in anticipation, probably about 10 minutes.
Sure.
The other one is our psychologist, so I would anticipate that she would go longer. We purposely set her to begin in the afternoon in anticipation that it potentially could take the rest of the day, but very well might not.
Okay.
And then we have other witnesses we could plug in to finish off the day if we need to.
Well, I mean, if we even get to it.
Well, that was the plan.
Right. Okay. Well, here's what I'm going to do. We will take a break for a number of things to happen. For the state to review these articles by Dr. Reisberg, I am inclined to allow him to testify. He was on the witness list at one point, and I know defense indicated he wouldn't be testifying, but I don't think that prohibits them from changing their mind. I see that I have received these 2 articles from the Court of Appeals that apparently came out today. so let me just make sure I understand what defense is asking to do. Is defense asking to revisit my earlier ruling as to whether or not Ms. Jacobs should be excluded? Or is defense asking that I reconsider my earlier ruling with regard to the scope of what she can be cross-examined on, or both? And Mr. Scott, why don't you come forward and put your name on the record? And I'm just trying to get a sense. I don't want to hear the argument right now. I just want to know, what is defense asking for?
Thank you, Your Honor. Ryan Scott, SCOTT, bar number 955267. It is not asking to exclude Ms. Jacobs. We're not raising that issue again.
Okay.
But it's more than just the scope of cross-examination. Although today's two opinions from the Court of Appeals, James v. Kane and State v. Houston, are relevant ultimately. I believe, I sort of skimmed them quickly because they weren't online until about 8:15 this morning, are relevant to that. But actually, more importantly than just re-arguing that, I have a copy of a transcript of this court's ruling from Monday morning, and I believe that can be forwarded to the parties and Your Honor. I would like to ask this court to clarify parts of its ruling regarding the scope of cross and how it got there, because as the court knows, I don't just do trial work, I also do appellate work, and the AG's office, the Oregon AG's office, which is fantastic, that has a number of great appellate attorneys, are also very, very skilled at sniffing out any possible preservation claim that they can make.
Sure.
And so I would like to, especially in light of some of the arguments in today's opinion, I would like to ask the court some clarifying questions about its ruling.
Okay. I don't have a problem doing that. What I will do is review these two cases to see whether or not I'm going to allow further argument on the scope that I stated earlier. But as far as clarifying the scope, I don't have a problem doing that. What would you like to know?
Certainly. Actually, if I wrote the questions down this morning after reading the transcript, so let me pull those up again so I can get them correctly. It's not specifically about how far we can go, but the basis for this ruling. All right.
Can I read it off of this?
And what I can tell the court first, if the court wouldn't mind, I can read part of the ruling and then tell you the questions that I would like to ask.
Hold on just 1 second before you do. Okay, go ahead.
All right, so what you had said is defense can also ask if Ms. Jacobs hopes that her testimony in the present case will assist her in potential negotiation of that investigation. I will not allow cross-examination into the specific acts Ms. Jacobs may have committed in that case. Like anyone, Ms. Jacobs is presumed innocent until proven guilty, and at least as of today, she hasn't been charged with anything. So with that in mind, here are the questions I would like to ask Your Honor.
Sure.
Does Your Honor find that the amount of sentencing exposure she potentially faces in state court is what we believe is years in prison, is not relevant to her degree of bias or interest?
No, I think you can ask that question if the idea is to ask her, isn't it true that if you're charged related to this case, you could face, X number of years, whatever it is. You're free to ask that. I mean, I doubt she'll know, but you're free to ask it.
Well, okay, so that would be relevant. One of the cases I can tell Your Honor, I believe it is State v. Houston, which involves cross-examination of a CARES representative about the relationship with CARES. And what I can tell the court is there was the employee from CARES who was interviewed downplayed the connection between CARES and law enforcement. And what the Court of Appeals said in that case this morning is that defendant was entitled then to offer extrinsic evidence of that relationship because it goes to bias and interest when the witness themselves downplayed the potential scope of that relationship. So that'll be something will come up later today. And is the reason you had mentioned that Ms. Jacobs was presumed innocent, is the reason that you're keeping out the specific acts that she did, because the specific acts go to ultimately to her exposure, are you keeping it out under 403 balancing, and is her presumption of innocence part of that balancing test? And what other factors go into the balancing test if the court is applying it?
All right. I'm keeping it out for a number of reasons. Some of these might directly answer your questions, some may not. But typically, when you're asking someone about crimes for which they have actually been convicted, it is only allowable to bring up for impeachment purposes the crime for which they were convicted without getting into the specific acts that they committed for that crime. I don't see why it would be any different in a situation where the person hasn't been convicted and has actually not been found to be guilty of that crime. But as far as 403 balancing goes, the factors I would rely upon are that it will be unduly confusing and prejudicial when we're talking about a situation where there is no conviction. She hasn't been found to be guilty of something, and to get into specific acts about what she may have done and what may ultimately be proven, I do think is unduly prejudicial. To get into what her potential exposure is, I agree that would be fair game.
The reason this is important, I think the difference between a prior conviction and possible pending prosecution is that they're admitted for actually, although two completely different reasons. A prior conviction isn't admitted for bias or interest. It is admitted because of the long history of felonies being admissible against any witness. The potential prosecution goes to bias or interest, and ultimately the scope, I think it sounds like the court agrees that the scope of her potential exposure is relevant.
Sure.
And the only, I mean, if she was accused of stealing, of potentially a theft 3, right? I mean, the state would be bringing that out, right? You're not going to lie to avoid a theft 3. But here we've got somebody whose exposure is for thefts of over $250,000, fraud specifically. And that would be relevant to the jury assessing her bias and interest in doing anything she can to get out of that. And because Your Honor foreclosed us from finding out exactly what she did by quashing the subpoenas, the only way we can get to what her actual exposure is by finding out, by asking her what she did. And I think today's Houston case would suggest that if she downplays that, then we get to offer extrinsic evidence. And so I would submit they're being offered for two very different reasons, a prior conviction versus pending prosecution. And I think that ultimately asking her just, is she aware of her exposure, and accepting that answer is inadequate to letting the jury know the scope of her potential interest in bias, and it would violate the Sixth Amendment right of confrontation.
One question for you, Mr. Scott. You said that and I know very little about the alleged, well, there's nothing even alleged, it's an investigation, but you said theft of over $250,000. Where do you come up with that figure?
A letter from Oregon Department of Justice.
Okay,
think
so
it's
that's
exhibit
the letter
400.
that we saw earlier. Okay, well, I will allow, and I'll read the case you're talking about, but I would allow a question about whether she's aware that the investigation, essentially the things that are in that letter, which I don't have in front of me at the moment, but I would allow a question, is she aware she's under investigation of theft of over $250,000? If the letter states the specific name of the offenses she's under investigation for, and I don't know if it does or not, but if it does, I would also allow that. But I'm not going to, unless that reading that case dramatically changes my mind, I'm not going to allow in-depth questions about what specific acts she's alleged to, or that she's alleged to have committed.
And thank you, Your Honor. Thank you for that. I would say there's a good chance we will have to renew our argument after she testifies.
Sure.
Because in light of the Houston case, if she downplays it or denies knowing that or denies her attorney told her about, or showed her that letter, then I think the Houston case stands for the idea that we can bring in extrinsic evidence of the bias at that point.
Okay. And I will read the Houston, I suspect that her testimony won't be done before lunch if we're going to take Dr. Reesberg too. So we can revisit the issue at that point. Ms. Herman?
I just want to point out, I don't know how much Mr. Scott was paying attention to Friday's hearing. I just wanted to point out and remind everyone that the DOJ attorney testified that there's no way she would know of what charges because he hasn't even made that decision yet. So there's no way she could possibly know what her exposure is unless she suddenly become a criminal prosecutor in the state of Oregon. She has no state criminal experience, only federal. The guidelines are very different. And he was very clear in his testimony that he has not indicated any charges, nor has he even decided what the charges are.
Sure, and if she indicates that she doesn't know, then that's what she'll say.
Well, I did listen to a lot of that argument, and what I can tell the court is he was also planning on potentially making an offer to Ms. Jacobs, and I would submit any person here who has legal experience knows the prosecution doesn't ultimately make an offer to someone without first evaluating what their potential exposure was. Now, we certainly, had we had the data, the investigation reports and the time to go through it, we could have figured that out. The fact that the state chooses not to figure out her exposure is not something that I think favors their argument.
All right, well, like I say, we'll give both sides a chance to read this Houston case. And for now, I've given you some clarification. So I'm going to ask the state to read these 3 articles by Dr. Reesberg. Roughly how much time do you think you'd need?
Just to be safe, Your Honor, maybe 30 minutes.
Sure. All right. Why don't we be in recess till 10 o'clock? I'm not expecting you all to read the Houston case right now, but Mr. Scott, I'll read it. And I may be able to come back, and when we go back on the record, say, yes, I think we have more to talk about later, or that I'm sticking with what I've just said.
I would ask,
Ms. Maxfield.
I haven't read it yet, but Mr. Scott alerted us to the second case, which was provided to the court. And it has to do with whether we would commit malpractice by not examining the witness with some specifics. So we need to read that too.
Sure. All right. So it looks like we have a half hour.
And another problem, Your Honor, is that I'm actually expected to appear in a status conference on a murder case in Hillsborough at 1 o'clock. Now, it's just a status check. It's something that depending on Judge Boucher's availability, might be something that could move until sort of the end of the day. But it would, if the court would like me to be here at 1, I would actually make the unusual request, not totally never happened, is if the court could call Judge Boucher and ask if it could be moved to this afternoon, later in the afternoon.
Well, I have no particular preference, Mr. Sky. I mean, there are two very capable defense attorneys here. I think you can talk with them and someone can make the argument when and if we get to it. I mean, I may read the Houston case and decide that the decision I've made is the decision I've made. But I'm not, at this point, I'm going to leave it up to the defense team to sort of figure out who can be present to make the argument, but I'm confident that one of you can make it. Let's go on break then. We'll let the jury know that we're getting a little bit of a delay, and let's plan to be back at 10.
Okay, just a lot to carry.